Boston Housing Authority versus National Conference of Firemen and Oilers.
Good morning, Ms. Hodge.
Good morning, Your Honor. May it please the Court, my name is Kay Hodge, and with my colleague John Simon, we represent the Boston Housing Authority. The Boston Housing Authority asked this Court to reverse the trial judge's decision confirming an arbitration decision issued by arbitrator Gary Wooters because it enforces a collective bargaining agreement in its 5th year in clear violation of Chapter 150E, Section 7A.
Do you have any cases or that would support the idea that evergreen clauses, at least here, that would support the idea that evergreen clauses are, because of Section 7A, are invalid?
No, I don't have any cases because obviously you could have a 1-year agreement with an evergreen clause and it would be acceptable for the first 3 years in theory.
But most public employee collective bargaining agreements are not 1 year.
No question.
And most of them have evergreen clauses, don't they?
I think that they do, Your Honor, but I think that what you have to understand, well, what I would suggest that Your Honor should consider is simply the following, that most public sector collective bargaining agreements may have evergreen clauses, but the legislature which created and passed Chapter 150E must have understood that. In fact, if you take the 150E and compare it to the National Labor Relations Act, what you find is that most of 150E comes from the NLRA. However, the National Labor Relations Act has no prohibition or limitation, if you will, of collective bargaining agreements to 3 years. And I would suggest, therefore, that what that suggests is that the legislature made a decision that they wanted to have that provision among those that would be applicable to public sector collective bargaining agreements. I would also point out that there are a number of states, and we cite in our materials a case out of Tennessee that has virtually an identical statute limiting collective bargaining agreements for 2-3 years.
So if we agree with you and there's a collective bargaining agreement that runs for 3 years, at the end of that 3-year term, until there's a new collective bargaining agreement, how do the parties know what the terms are? What's the deal? How will they know?
There are a number of conventions, there are a number of cases that cover that issue. It's under the National Labor Relations Act, for example, when a contract expires, it can expire, but what it means basically is that there are some provisions of that agreement, and in particular, and this court has so opined in agreement with the U.S. Supreme Court, that when a collective bargaining agreement expires, certain terms are no longer operative, the most important being the grievance and arbitration procedure. And for example, Old Rochester, this court determined that in the event that a particular grievance arose prior to the termination of the agreement, it should continue to be processed under the grievance and arbitration procedure.
What happens if the grievance arises after?
If the grievance arises after, then I mean it would not be subject to the arbitration provisions, and that is applicable to both to the public and the private sector. I guess.
So a public employee who is disciplined, for instance, after a contract expires, would have to pay out of his or her own pocket, and the union wouldn't. It's not a union case anymore; it's a personal case.
No, I think that you would bring under essentially a 301, or what I refer to in the federal courts is it would be arguably you could bring an action in which an individual would be represented by the union, but it wouldn't be under the existing grievance and arbitration procedure. But I think that what we're talking about, and I understand the puzzlement.
But what would the procedure be?
You could argue that there had been some other violation and go to another forum. Perhaps you might file it with the Labor Relations Commission because there are some obligations of an employer not to unilaterally change the terms and conditions of employment, which are applicable, and you could bring essentially a refusal to bargain charge before the Division of Labor Relations.
But doesn't it make a lot more practical sense to have evergreen clauses?
Your
To
Honor,
preserve the status quo until such time as a new agreement takes place?
You know what? It may be because of their history and because of the use that many public sector employers and unions find valuable, that therefore we should there should be a provision in the statute. Unfortunately, the statute before you is Chapter 150E, Section 7A. And it says with absolutely clearly, it says that public sector collective bargaining agreements shall not exceed 3 years.
And it
Why
doesn't.
isn't it possible to read, why isn't it possible to read that language to mean you cannot agree to a collective bargaining agreement that has a term for longer than 3 years? That's not necessarily inconsistent with the idea that at the end of that 3-year period, if there is not a new provision for that interim, these provisions will stay in effect. I mean, I don't see that those are necessarily inconsistent with each other.
Well, I think that what you're talking about, Your Honor, is essentially, if I could put it in somewhat different terms, what you have is a situation in which you have one collective bargaining agreement, you're seeking a successor agreement. Right. That's not what you have in front of you. What is absolutely clear is that the BHA advised the union that it was going to be terminating all firemen operations and would be laying off all of the firemen. And therefore, there was no need for a successor agreement because that agreement would have only covered the firemen. And there is predicate for this. We cited in our reply brief.
You had one agreement between 98 and 2001. Then you had an MOA that lasted from 2001 to 2004. And you're saying to me that there was going to be no overall collective bargaining agreement?
No. What we're saying is there was under the Evergreen Clause, we were bargaining for a new contract. And it was in 2006, the 5th year, that the arbitrator held, and I think in answer to your question regarding term, wasn't the term, couldn't you have a term and other provisions? In fact, the arbitrator explicitly held in his decision the fact that in this case, what you have is the 3-year collective bargaining agreement continued in effect. In fact, what the arbitrator stated in his decision is the fact that the arbitration, that the March/April of 2006, in March/April 2006, the 2001-04 MOA, including Attachment A, which was the limitation on the ability, the minimum manning or minimum staffing provision, was in full force and effect. Right. So consequently, what he did is he applied this contract, and he said a contract continued to exist. And therefore, it is a contract. It's the same term. I mean, I understand, I think, your question, but I think that the statute specifically suggests that the collective bargaining agreement shall not bind a public sector employer for longer than 3 years. It does not mean, in answer to Justice Spina, that the parties could not, or to Justice Ireland, that the parties could not agree to have a new collective bargaining or even extend it while they're negotiating a new collective bargaining agreement.
But in practice, that's exactly what happens. I mean, it's an anticipatory contract, so that when the 3-year contract expires, the parties agree that they will continue the provisions of the previous contract, and when they do negotiate a new contract, it always reverts back to the day after the last contract expired. It's an interim agreement, isn't it?
Well, I think that one can argue that it's an interim agreement. I would suggest to Your Honor that you look at the Tennessee case and you think about the reasoning. What the legislature is saying, I mean, because you can say, but they really intended that they could go on and the parties could contract privately to agree to ignore a legislative pronouncement. I mean, that's essentially what you're saying. That because the parties decided they could just go ahead and include an evergreen clause. The facts of the matter in this case is that the evergreen clause had in fact been in the agreement for a long time. As a Superior Court judge found, the parties, in fact, the BHA, had proposed to both eliminate the evergreen clause and to eliminate the minimum staffing, and had bargained about that for 2 years, in the 4th and 5th years, if you will, of this agreement. And then getting back to Justice Spotsford's, the issue or my response to you, Justice Spotsford, we made a managerial decision to no longer have firemen. And we therefore laid off all the firemen. So there was no need for a successor agreement. And while one might argue that you can have evergreen clauses that bridge between one contract and another, and indeed there are cases that suggest that the parties kind of just assumed it and raised a different question to this court. I think the Nage case is an illustration of that. The fact of the matter is that in this particular case, the BHA told the union that it was no longer going to have firemen, a managerial prerogative. We cite the we cite a national maintenance company case in our reply brief.
That gets to your second, it is your second argument, right? That you say it's managerial prerogative, it's in excess of the authority to bargain about anyway. I mean, whether there's an agreement or not, that would be your argument, correct?
Our argument would be that this particular subject,
Right.
a public sector employer subject to 150E cannot bind itself for periods, and I believe this court has said periods longer than a year. I would suggest to your honors, in this case, that particular provision was now in its 5th year. So we're not even talking about a provision that was merely, that was within a contractual period, but relatively beyond that. And I would argue to this court, the language of 150E, Section 7A, is clear and unambiguous.
What was,
Now,
the,
if I
purpose,
can
what was the purpose of that language?
I think the purpose of that language was to
And
prohibit.
not what do you think? I mean, is there any statutory?
There's no statutory interpretation that we were able to find, except that the words themselves are plain, and by this court's own prior precedents, you do not look outside of those words when the plain and ordinary meaning can be discerned from those words. And here I would argue to look at the practice of the parties individually to have evergreen clauses is looking beyond and really finding a public policy basis. And I believe that the legislature, which decided to enact Chapter 150E, knew well about public sector collective bargaining. And indeed, in this particular case, I would argue another point that we make in our briefs, and that is that this is virtually a contract in perpetuity.
But you can declare impasse. I mean, you've got a lot of remedies.
Your Honor, I believe I would beg to disagree with you in this circumstance.
Why?
What the arbitrator decided and what the Superior Court judge affirmed was a determination in which the arbitrator found that a contract continued to be in effect. And based on this court's prior decision in the Mass Community College case, which we in fact cite to you, the impasse procedures are inapplicable in midterm of a contract. Because let's just assume for a moment.
Wait, hold on. Clearly, you had an MOA that ended in 2004. There is an interregnum period, if you will, that you are in the middle of in 2006. So the arbitrator, at least as I understood it, was saying, I'm not dealing with those outside law questions. That's for a court. I've got a contract in front of me. It says these people work here. That's how I'm going to interpret it. That doesn't mean you couldn't have, in the course of bargaining, rather than saying we're just not hiring them, said we've reached impasse here and triggered what follows from that.
Justice Bodford, the language of the Evergreen Clause in this case said that the contract shall continue in effect until a new contract is agreed upon. Now,
so are you suggesting that any contract with an evergreen clause eliminates the possibility of impasse? Is that what you're saying?
no. What I am suggesting is that you have to apply Section 7A to be a 3-year term, that the parties certainly can agree to have another contract, which is an extension or continuation of that contract, while they're bargaining. Basically, there are a number of cases in which the parties consider it and at that moment in time determine whether or not at that moment they wish to continue. What you are essentially saying is at the beginning of this contract term, indeed even earlier than 2001 when the MOU was agreed upon, the parties agreed to evergreen language that was in this contract that perpetuates this agreement going forward for longer than 3 years.
Okay, but now you've confused me, because I read Mass Community College Counsel to say that as long as a contract is in effect, the impasse procedures do not apply. It applies only when there is no contract.
Correct.
And then you're telling me that that there can be an evergreen clause which says the contract remains in effect until a new agreement is reached, but you can reach impasse.
No, I'm saying you cannot reach
Okay,
impasse.
then you misspoke
No,
earlier.
Your Honor, I'm sorry if I
Okay.
misspoke.
Uh,
I will just tell you that here, the arbitrator decided that the contract continued to be in effect.
Right, I understand
That's
that.
what he decided.
Now, going back to what the world would look like if you win, okay?
Mm-hmm.
I assume there would be nothing that would prevent the parties, after the contract has expired, to say, we agree that certain provisions will remain in effect.
You can agree, certainly.
Okay, so there can be essentially a new partial agreement going forward.
You could agree to a whole
All
agreement.
right, and I
going
gather
forward.
also under Section 9, the impasse provision, that terms and conditions of employment would continue until impasse is reached.
Correct.
So those provisions would continue until a new agreement is
And
reached.
the impasse procedures would apply if there is no interim agreement, going back to an earlier question. What happens in the event that there isn't a contract? What it basically means is the parties continue to bargain, and at some point the parties can go through the procedure, the impasse procedures. Here, what the BHA decided was that it gave notice that it was no longer going to have this operation. It was going to be laying off all of the attendant individuals, and it bargained the impact of that decision, which is what the law requires in this instance. And that is the only way you can give meaning to Chapter 150E, Section 7A. Otherwise, you're saying private parties can decide to have an evergreen clause. It could be for 1 year, it could be for 2 years, but in this case, it was until the parties agree to a new agreement. That is what this arbitrator continued, and I suggest that is what the trial judge decided was the basis of her decision affirming the arbitration award. And I suggest to Your Honors that there's no underlying agreement here because of the effect of Section 7A, which limits collective bargaining agreements to 3 years.
Thank you, Ms. Hodge. Mr. Sills?
Thank you. May it please the Court. My name is Ira Sills. With me is Nicole Horberg-Dechter. We are here for the Appellee Union Local 3. And I want to address...
Mr. Sills, can I ask you, you suggest in your brief that if we conclude that an evergreen clause cannot extend a contract beyond 3 years, that would destabilize collective bargaining in the public sector. Is that really the case, and why?
Well, I think it's a part of the question that some of the other justices asked. These clauses are prevalent in public sector collective
They
bargaining.
may be prevalent, but...
Excuse me?
They may be prevalent, but why could they not be interpreted to say you can agree to a new MOU?
Well, first of all, I want to first address the misstatement of the facts of this case as it applies to this issue. First of all, the evergreen clause in this case, as interpreted by arbitrator Wooters, who the employer does not challenge in his findings whatsoever, said that the evergreen clause in this case does not extend indefinitely or ad infinitum, as it was characterized by the appellant. The appellant characterized it as the union being able to hold hostage.
Well, why is that not the case?
It
What's
is not the case.
What's the triggering termination
Yes,
of that?
yes. It's not the case because the arbitrator ruled in this case that this particular evergreen clause had a provision that said it stays in effect until a new agreement is reached, but the parties must bargain in good faith. He interpreted that, and we agree with it, and Justice of the Superior Court, Judge Giles, agrees, that means that only so long as the parties bargain in good faith does that bind both parties. And by that he explained, and she explained, that if the employer, the BHA here, bargained in good faith to impasse, as suggested by Justice Botsford, they could exercise self-help, as the law allows as well, to declare impasse and implement their final and last offer. That's what 150E provides under good faith bargaining. That's what the arbitrator interpreted this as being it. So it's not that the employer is held hostage at all. They just, in this case, engaged in self-help before they had the right to do so. But getting back to your question, Justice Cordy, which I haven't answered, I think in collective bargaining in the public sector, it's different from the private sector. Employees cannot go on strike. It is illegal to go on strike. So there's no closure mechanism.
But aren't there protections? I mean,
Yes.
the world doesn't end at the end of a collective bargaining agreement if there's no evergreen clause. All the mandatory terms of bargaining remain in effect. right?
I agree.
Wages, terms and conditions of employment.
I agree absolutely. I think all the mandatory subjects of bargaining under 150E, Section 10A, employers cannot make unilateral changes until they reach an impasse. That's already there. So actually, evergreen clauses don't grant that much else. What they grant, that is what Justice Ireland and Justice Botsford were asking about, is if somebody is fired, for example.
But they're not, here we don't have a filing, we have a management decision to terminate all firemen.
Yes.
I mean,
this
if you
is-
have an individual
Yes.
fireman is terminated for cause, let's say,
Yes.
that's a different situation as to whether you then, you know, what is the disciplinary procedure, how many hearings do you have, and so on and so forth. But this is a different one. I mean,
It's-
how do you bargain to impasse when management has decided it doesn't need firemen?
That's very easy. That's what we as labor lawyers do for a living. We all know about this delicate dance of bargaining to impasse. It's our jobs. About how to
I
get
understand
there.
that, but if you don't want to have firemen, what are you bargaining
You
about?
you proposed to the union that we want to eliminate firemen and eliminate minimum staffing, which they had done in the bargaining in this case, as indicated by the arbitrator's award. And then they go through the process. And at a certain point, you reach an impasse after you've exhausted all their attempts. You may or may not have tried to bring in a mediator. You try your best to reach an agreement. You have as many meetings as possible. You finally deliver a final proposal, which was never done in this case, on all issues, and you say, that's our final offer. We believe we're at impasse. This is what labor lawyers do for a living. It's our job to know when that occurs, how to get to it, and how to do it in good faith, because an employer must get there by good faith bargaining. And one of the prohibitions about that, Your Honor, is they can't engage in unilateral self-help before they get to that impasse to change the terms to get what they want first, and then say to the union, okay, now come to us and get back those jobs. But
Mr.
to your
Sills,
question, Your Honor, the layoffs aren't different from discharges, because if the terms...
Are or are not?
They are not different, because the question raised by the justices was what happens to an employee if they want to challenge a violation of the union contract. In this case, the violation could be, we had a minimum staffing of 16 people, you laid us off, we want to go to arbitration. The reason you have evergreen clauses is so that arbitration process stays in effect, so there is a forum. There is no other forum in response to the question asked to counsel for the BHA.
Mr. Sills, how do we give any meaning then to
Yes.
150E7A? In any meaning at all. All I can see is that you go from a 3-year to a 4-year to a 5-year, 9-year, 10. Doesn't matter if you have an MOU or you don't have an MOU.
Yes.
Well, as if the agreement continues ad infinitum. So what are we doing with that legislative determination?
Well, the agreement does not continue ad infinitum, as was said earlier.
No, I mean, so that somebody doesn't reach impasse, because, you know, if you say we're at an impasse and an arbitrator determines that you're not at an impasse, that has very severe consequences too,
Yes.
correct?
Yes.
So essentially, you're saying to me, I think, this just goes on and on and on and on.
No, I'm not saying that at all. First of all, with regard to Section 7 of 150E,
Right.
We have ample case law on this. The State Labor Relations Commission, now the Division of Labor Relations, has ruled repeatedly on this issue, and they have treated 150E Section 7 as requiring 3-year contracts, but have repeatedly ruled in the town of Burlington and other cases we have cited that evergreen clauses do not violate Section 7. But they're just an administrative agency. This court itself, at least 2 different times, has dealt with the issues of evergreen clauses and the conflict and tension between the clear language that my sister refers to in Section 7. And in the Nage case, this court specifically discussed that tension with Section 7 that specifies there shall be 3-year contracts.
Right, but in Nage, the parties didn't dispute that the agreements remained in effect, so the issue was never reached by the court. So how can you say we endorsed it?
Well,
when
I
the
don't think
parties didn't-
you held in that case. It wasn't the holding
So
of
the
the
parties
case.
do not dispute that the agreements are still in effect.
Right.
That's at page 450.
Right, but it
So
also,
why should we go out on our own and say, the parties don't dispute this, but we're going to ab initio raise the issue ourselves and decide an issue which the parties contend is not before us?
well, I say that the court, as in the Local 589 case, both cases, it's not only the Nage case, they both reviewed evergreen clauses and held, as the appeals court has had in Gustafson, that those clauses were not invalid. Now, in some cases, they weren't at issue. You're right. But the Labor Relations Commission has repeatedly ruled that they are valid, and there is no court in the country except the appeals court in Tennessee that has taken the position espoused by my sister.
Mr. Sills,
yes.
help. You haven't really answered my question.
I'm sorry.
No, I mean, it's perfectly okay. I mean, I understand that you turn to apply a precedent, but again, try to explain to me why the language of 7A is given effect in the situation that we have now. You have an MOU that expired, right?
Yes.
And we're into the 5th year. Why, if I were a legislature who had enacted 7A, I'd say this is exactly what I don't want.
Well, I don't think that's what the legislature meant. I think 7A with a limit of 3 years, and this is what the Labor Relations Commission has ruled in interpreting why they have legitimized evergreen clauses, really was incorporating something that's the holding of numerous cases under the National Labor Relations Act. The National Labor Relations Act, the NLRB and courts have held that contracts should not be for more than 3 years for the purposes of not prohibiting other unions from coming in and representing the workers. There's a rule in the private sector that says a contract can bar an election petition by a rival union. And the NLRB and the courts have said, no, you can't limit democracy in that way. There can only be a 3-year bar.
It can only be written for 3 years.
It can only be written for 3 years, and if it's written for more than 5 years, that's okay, but it can't be a bar to another union trying to represent the workers. That's what we believe happened in 150E Section 7.
And what's your source for that? Just by saying this is what the NLRB has done?
My source is the decisions of the Labor Relations Commission that we cite that have upheld evergreen clauses consistently in Massachusetts.
There's no legislative history on this?
No, unfortunately in Massachusetts we often lack that, and this is one of those cases as I understand it. We have found no legislative history. We are suggesting that the court defer to
when was this enacted?
in the mid-1970s, I believe. I don't
And
have
is there a comparable provision under the federal?
No, I was suggesting under the federal law there is no comparable provision. There is case law that uses the 3-year limit on agreements as a bar for rival election petitions so that unions cannot hold the workers prisoners to one union so there can be a rival election. But in this case, it's important to note that the evergreen clause, as interpreted by the arbitrator, if I can get back to this issue, did not find, as the BHA suggests, an ad infinitum obligation of the employer.
But going back to that, I assume there has to be a finding of bad faith in order for the contract to end.
No. There's 2 ways that the case suggests one can end the contract. If the employer bargains in good faith to impasse and declares impasse, which is something that all labor lawyers do and know how to do, then it's over, and they can implement their offer. They have to reach impasse by good faith bargaining. That's number one. Number 2.
Where do you find that in either the decision or in the language of the contract?
The arbitrator found expressly that the agreement does not bind the parties ad infinitum. He said that if the union, strike that, if the employer reaches impasse, they can implement their offer. Because he interpreted the language in the contract, in the arbitration decision, it says it requires good faith bargaining. It says the contract stays in effect, but then there's a second sentence that says the parties must engage in good faith bargaining. And by that, he interpreted the language to say good faith bargaining allows impasse to be declared and implemented.
I should go back, but I remember him saying that the parties must continue to engage in good faith bargaining. I don't recall him saying that if they engage in good faith bargaining and reach impasse, then. But you're saying that it's there, the language of impasse is there in his...
Yes, he declared that it wasn't an ad infinitum contract.
Well, I understand that, but I had read him to say there has to be, if the party is no longer negotiating good faith, then
But you're
by the
saying,
terms of the contract, but you're saying you can negotiate in good faith and still have the evergreen clause.
Yeah, it's complicated because if the union bargained in bad faith, that would give the employer an opportunity to declare and implement, or if the employer bargained in good faith and got to a good faith impasse.
when you mention impasse, it's not, that sort of operates as, that's outside of this contract. That's the way that that's what good faith bargaining means. Is that what you're saying?
I think it's actually both. You're right, that's the law outside of this contract, but I think the arbitrator, if you read his case carefully and read our commentary in our brief, he incorporated that legal principle into reading the meaning of that language that the parties must bargain in good faith. So he gave them an out. And by the way, that's been our position throughout this case. We have always taken the position that this is not a contract that goes on ad infinitum. We said there is a safety valve there for the parties to liberate themselves from an endless being bound, if you will, by the contract. And Judge Giles, of course, found in accordance with our position and the arbitrator's position the same.
So how's the public interest served?
Yes.
In these circumstances? I mean, certainly all public agencies have a very important charge to protect the public interest. How is that served?
That's an excellent question, Justice, and I think it's served by the fact that all of us who practice in this field in the public sector operate on these rules, and I advise my clients all the time, look, the employer can bargain to good faith impasse, and they can implement. You can't hold them up as long as you want. They have the power to do that, and they will hire expert legal counsel like Kay Hodge or others who know these rules, and they can bargain to impasse. So the public is served by the fact that they can exercise, the employers, public employers, have the right to exercise those powers, and they do. They move towards those things, and they do it lawfully and in good faith. The problem.
Mr. Sills, do I understand you that if there's a management decision
Yes.
that, for example, for technical or other reasons, a group of employees is no longer needed
Yes.
in a public sector,
Yes.
and there's a 3-year contract and there's no agreement, I'll skip over the MOU in this case, there's no agreement to extend the contract, that the only option that the management has is to bargain to impasse?
No, not at all. And I'm so glad you asked that question, because the arbitrator found in this case that there are 800 other employees at the BHA. There's not a scintilla of evidence presented by management or before the arbitrator in this case that any other employee at the BHA, other than these 16, had any bar whatsoever on them being laid off. An employer can lay off employees under any collective bargaining agreement. They have to do it by rules. It might be by seniority or others. But
I thought this was a functional problem. These employees no longer play a function, a necessary function in the operation, wasn't?
No, that's not the finding of the arbitrator and not the facts of this case. That's what the employer would like you to believe, but it's not. It was disputed in the case. The arbitrator said, the employer says that, the union disagrees. I am not ruling on that because I find it's irrelevant. The issue in this case, he said, was, is the contract in effect that mandates minimum staffing of 16. And to get back to the Chief Justice's question, no, employers are not prohibited from laying off employees. They do it all the time. They can lay off under any contract at the BHA except for this one. This contract had an extraordinarily unusual clause saying they had to keep a minimum number of staff, 16 people, that had been negotiated down from much higher numbers in prior negotiations for that 2001, 2004.
So
they can in every other situation, absent this kind of clause. The problem with this case is that they entered into a provision that bound their hands from laying people off.
But why would one not read in precisely that circumstance an employer saying, I understand, I don't know what's going to happen in 3 years' time. I'll agree with this for 3 years, but I'm not going to agree with it for longer than 3 years. I mean, essentially what you've told me that they now have to keep these people that they don't think are needed any longer because they agreed to a 3-year contract?
No, I think, I guess if they had forethought, they would have said, we need to eliminate that evergreen clause if we're entering into this minimum staffing provision.
And what do you think the chance of them being able to reach an agreement by eliminating the evergreen clause was?
It would have been resisted, I'm sure. The union would have objected. And then we have the impasse procedures available to the employer, which are there. But they need to negotiate with the union when they have this kind of clause, which is unusual and not true in most cases. So I don't want the court to believe that a minimum staffing requirement is typical in public sector collective bargaining. It is not. This came as a result of the parties' union agreeing to massive job reductions in its prior contract. The arbitrator found that there were 29 employees before that 2001 memorandum of agreement. The union almost halved their workforce.
So why isn't this provision subject to
Yes.
our case law that suggests that minimum mandatory staffing cannot extend beyond 1 year?
Thank you for getting me on that track, Your Honor. It's the right question to ask. Those cases that limit those kinds of clauses to 1 year are all in the setting of when a executive of a city or town, or it could be the Commonwealth, are required to get legislative funding from the legislative body in their town meeting, city council, board of aldermen, whatever. So the holdings of those cases rule clearly that the executive, the mayor or town manager, can only bind for 1 year because it has to be subject to legislative funding. That model doesn't exist for the BHA.
You mean the BHA doesn't have to go to either the federal government or the state government to get money every year?
They have to go to the executive branch of the federal government and the state government. They have no relationship with the legislature whatsoever.
What difference does that make? It's a process that they have to go through every year that is not without doubt. Isn't that the crux of those cases that say it's the 1 year rule?
No,
it's not that you have to go to the executive. It's that you have uncertainties in your annual funding.
No, actually, I disagree respectfully with that, Your Honor, because those cases rely on sort of a non-delegability doctrine that's the legislative prerogative of the legislative bodies of the town or the state that have to fund those kinds of agreements. They never have dealt with a case involving the executive. In this case, there's no limit in the budgets on the BHA, as the arbitrator found. They get a block grant from the federal government. Mostly it's 80% funded by the federal government. It doesn't limit what they do with that money, except there's certain limits on capital versus operational. But within that framework, it's completely up to the discretion of the housing authority without limit to spend that money on staffing or anything else. So on those cases, there's two kinds of non-delegability cases that are involved here. One is the legislative funding issue, and if you look at those cases carefully...
Mr. Sills, I hate to interrupt you, but your time is really...
I'm sorry.
No, you were answering Justice Fina's question, and that's fine, but it's when you start to go on to another argument that I interrupt you.
Okay.
But thank you very much.
Thank you very much.
SJC 10626, Blair and others versus Mass Department of